Hi, welcome to VLF's video education series. Today's topic is company agreement considerations. I'm Charles Vethan.
I'm Sam Shinoda.
And let's talk about what goes into a company agreement. So Sam, first of all, what is a company agreement?
A company agreement is basically the structure of how your company is organized, who controls it, how profits are distributed. A lot of considerations go into company agreements, but for each individual company, it's going to be a different thing.
So one of the first topics we address with our clients is what type of company do you want set up? Is this going to be a holding company? Is it going to own the stock of other companies? Is it going to be an operating company? Will you be just handling real estate or a single purpose entity? You make that decision up front. Sam, this kind of dovetails into the management and control of the company. So what are some of the issues that we advise our business clients to consider with respect to the issue of control?
Control, there's several things you're going to need to consider. For example, which partner is going to have a majority of control, if any? If there's two partners, is it going to be split 50-50? In that case, how do you finish a tiebreaker? If there's more than one partner, or if there's multiple members coming in the future, how are you going to divide their rights? So if there's future members, who decides how much power that future member has? Is there future investors? Does that investor have any rights? There's various considerations you should take into account when managing control of the company. But that should be a discussion amongst the members of the company.
So what that really dovetails into is dilution of the shares, how control is allocated, and sometimes what we do, Sam, is we structure different classes of shares. So not every class will have the same rights.
The great thing about company agreements is it's like cooking. You can create a lot of different variables. So you can create a Class A that has all the control and has rights to distributions. You can create a Class B that has no control but still can have any distributions. Or you can have a Class C who has neither of those but may become a Class A or a Class B, depending on how they play in the future.
So the different classes, it's not mandatory, but it's definitely something we ask our clients to consider when they discuss and contemplate how that company will perform in the future. Along those lines, one of the other topics we discussed earlier today is on corporate opportunity. So it's important that when a company is structured, the members, the shareholders or partners decide what the business of the entity is. Because in Texas and in California, when you file a company agreement, you file it for any business that's legal under the sun. But you may want to restrict the type of business the company is involved in and state that in the company agreement. Why would you want to do that?
So the reason you want to isolate the type of business that the company does is so that not every business opportunity that comes to the company is for the company. So the company does not have rights to every company opportunity. That means that if a member, for example, learns about a contract that's outside the scope of the company's business, if they engage in that contract, they're not stealing the company's opportunities, which means they won't get sued for that.